Thank you. Good morning. Can I welcome everyone to the 7th meeting of the Justice Committee in 2014. I can ask everyone to switch off mobile phones and other electronic devices completely as they interfere with the broadcasting system, even when they're switched to silent. No apologies have been received. Item 1, the committee is invited to agree to consider item 5 in our work programme in private. Are we agreed? Keep up with me. Keep up with me. Right, it's a sunny day. Be bright and breezy. Item 2, EU engagement. This is an evidence session on the UK Government's 2014 EU opt-out decision. I welcome to the meeting Rosanna Cunningham, Minister for Community Safety and Legal Affairs. Good morning. And government officials, Neil Rennick, Deputy Director, Law Reform Division, Danny Jameson, Policy Manager, Criminal Law and Licensing Division, and Alicia Mackay, Legal Services. And Minister, I understand you wish to make a short opening statement. Please feel free.
Yeah, thank you. I thought it just might be helpful because this is quite a technical exercise, and I thought it might be helpful just to give a few pages of context. Now, I know that the committee has already received evidence from the Cabinet Secretary for Justice, but I did think that it would be useful to make some opening remarks. We have known since the Lisbon Treaty was agreed in 2009 that a final decision on UK participation in around 133 justice and police cooperation measures needed to be taken no later than 31st of May 2014. I should perhaps highlight at the outset that this part of the treaty, commonly called Protocol 36, deals only with pre-2009 justice and home affairs measures, if you like, a kind of frozen corpus of EU law, and not measures agreed under the new legal bases provided by the Lisbon Treaty. The UK has the separate ability to choose whether to opt in to individual post-Lisbon Treaty justice and home affairs measures on a case-by-case basis. For the pre-Lisbon measures, the UK must exercise a block opt-out, but can choose to opt back in to specific measures. And the 5-year window following the Lisbon Treaty provided ample opportunity for the UK government to undertake engagement with devolved administrations on whether or not to exercise the block opt-out. Scottish ministers wrote in April 2012 and again in August 2012 expressing our strong interest in the potential implications of this decision for Scotland's devolved justice system and stating clearly our strong preference to remain fully opted in to these measures. The pre-Lisbon Treaty justice and police cooperation measures, the so-called third pillar, includes some elements that are defunct and do have limited impact. However, it also includes measures that are of very significant importance in investigating cross-border crimes and bringing serious and organised criminals to justice. And these measures include the European arrest warrant, provisions relating to membership of both Europol and Eurojust, the joint investigation teams and the sharing of information and intelligence. And the view taken by Scottish ministers, as well as police, prosecutors, legal professionals, academics and a House of Lords EU Select Committee inquiry was and remains that the benefits of opting out of defunct or ineffective pre-Lisbon measures does not justify risking losing those measures that are essential for tackling cross-border crime. Unfortunately, UK ministers didn't consult with the Scottish ministers or Scottish justice agencies ahead of their initial announcement of their plan to exercise the block opt-out from the 133 measures, or their subsequent decision to seek to negotiate with the Commission and EU member states to opt back in to 35 measures. UK ministers formally confirmed their decision to exercise the opt-out ahead of the 31st of May 2014 decision. Our priority now is to seek reassurance from UK ministers about the negotiation process, and in particular that there should be no gap between the opt-out decision taking effect from 1st December 2014 and the UK opting back in to the 35 measures. As the Cabinet Secretary for Justice did indicate in his letter to the committee on 18th February, he wrote to UK ministers last month seeking an update on the negotiation process and reassurance about any potential gap. So I can update the committee that the UK ministers have now replied. They have stated that for their part they place a great deal of importance on avoiding an operational gap and believe it is in everyone's interest to reach an agreement that provides operational and legal certainty. They have also reported that other member states agree it would be beneficial to conclude matters swiftly and that negotiations with them and the Commission are in process. And of course, we will continue to press these matters with the UK Government. In that connection, Home Office Minister Karen Bradley has offered to come to Edinburgh for discussions with Scottish ministers. We're minded to accept the offer, although as this information has only recently reached us, it's too early to give a date for that meeting. Convener, I'll be happy to answer further questions that the committee may have about the process.
Before I call, I think I'll call Roddy first, who's our reporter, to ask questions. Could I just ask for an example of how the European arrest warrant operates, I think, for the record, when issued from Scotland, and alternatively when it's issued from a European jurisdiction, because that seems to be one of the key issues about how effective it is in terms of being served, but also in terms of the speed at which it can be operated. So it would be quite useful, I think, for the committee to know about the European arrest warrant process.
Well, I think it's fair to say that the experience that Scotland has with the European arrest warrant would, on the face of it, seem to be quite different to that south of the border, in that we're not seeing the kinds of issues and concerns that are being raised south of the border. We're not seeing it being used as a in any kind of trivial way from either side. We're not seeing difficulties with it, and the experience of it has been largely positive. It is also fair to say, I think, that that most of the practitioners south of the border are happy with the European arrest warrant as well. I don't think that the concerns about the European arrest warrant south of the border are coming from the people who are actually using it in practice. And certainly there have been no concerns expressed by practitioners in Scotland at all. It is difficult for me to make a comparative assessment, given that we are obviously only dealing with it from the Scottish context here. And from our perspective, it works well. I can give a couple of examples of when it's been used, but that doesn't necessarily compare to south of the border, so I can't really. I mean, for example, in 2008, a chap called Marek Harchar was arrested within 1 day of the issuing of the extradition request and was returned swiftly to Scotland from Slovakia to face justice for the murder of Moira Jones. And the warrant allowed clothing and other property to be seized from him before he could destroy it, helping to lead to a successful prosecution. And it's the speed of that that is important, that the fact that you don't have a long drawn-out process in order to achieve it. The extradition might have been achievable in other ways and previously, but not at the speed that this allows it to take place. There was another case more recently in January 12, a violent attack and murder in Edinburgh took place, and Gregors Gamla was arrested within 5 hours of issue of the arrest warrant, and that was achieved using the system, the EAW system, but was also facilitated obviously by direct contact between Scottish prosecutors and the authorities in Poland, and that was actually facilitated by the EU European Judicial Network, which is a different issue, but one which is germane to this particular case as well. So there's a couple of cases where the incredibly swift ability to act under the arrest warrant was allowing the whole of the criminal process to go much more quickly than it otherwise would have done.
And I think it's interesting that you've raised the point of preserving evidence, which perhaps one might not have thought of immediately. So that was very helpful. Roddy.
Thank you, Convener. Morning, Minister. Perhaps I could just ask for a point of information and detail. Are there up-to-date figures for requests for a European arrest warrant as far as Scotland's concerned, and the number that we, Scottish Government, has sought?
I don't know whether. Oh, I've got some. Yeah, actually, I'm looking at them here. Sorry. I have information from the International Cooperation Unit of the Crown Office, and there is information here relating to 2012 and 2013. So do you want the 2013 figures, or do you want the comparative figures?
20, well, both, if there's not too much time
right.
here.
Okay. They look as if there's not a great deal of difference, to be honest. In incoming, and that's where we're receiving warrants, we had in 2012 152 requests, and in 2013 149. They resulted in 101 arrests in 2012 and 102 in 2013. The number of surrenders on incoming requests, I presume that just means whether actually the individual gets handed over or whatever, was 89 in 2012 and 121 in 2013. There's information here about hearings and appeals. Outgoing requests, where we are actually sending elsewhere, numbers of requests received for assistance, 32 in 12 and 25 in 13. Number of returns to Scotland, 7 in 12, 12 in 13. So certainly we get more requests than we issue, but then you would expect that, since this is a jurisdiction of 5 million and you're talking about the whole rest of the EU when you're talking about out with us. So looked at on that basis, you wouldn't really expect anything different, I don't think.
Yeah, so, I don't want to speak for those south of the border, but one of the issues south of the border is they take the view that that kind of balance between incoming and outgoing requests, which looks fairly similar, is kind of to the disadvantage of the justice authority south of the border. But anyway, that's their view.
To be honest, and you'll appreciate we don't have these figures, but I imagine almost any individual jurisdiction in the EU would have to show the same thing, because outgoing requests are only emanating from your jurisdiction. Incoming requests are going to come from a huge number of different potential places. So I suspect that almost any jurisdiction in the EU would be able to offer you figures that showed that imbalance. And I don't really see, frankly, how that invalidates. I mean, our position is that that can't invalidate the benefit that you get from the European arrest warrant.
In relation to the European Judicial Network, my understanding is really it's a kind of information sharing as much as anything else, and seem to be quite a useful tool. Can I take it that in discussions that you might be having with the UK government about this, that you will be kind of making the case for continued participation in the network quite strongly?
Well, we are making that case quite strongly. I mean, you know, it is the one outstanding one where we genuinely feel that, or at least certainly the Lord Advocate genuinely feels that there is an enormous benefit to be gained by the continued engagement in that way, and are kind of viewing, I think, with some concern the fact that that would have to revert to some kind of much more informal process. If the entry to the European Judicial Network does not continue. I'm just having a look. I think there are. I have a very. I think there is a specific sort of case, and I think there's a kind of tendency to forget that a lot of legal processes are about small bureaucratic things, about bits and pieces of administrative necessity that have to go backwards and forwards. And there is an example that can be given as to how the European Judicial Network has made a big difference here. There was a case in July 2013 when an essential witness in a High Court prosecution had returned to Poland and had refused to return to Scotland to provide evidence in the trial. And the case was going to call 3 days later. So the Crown Office would advise them to 2nd of July that this person wasn't coming back. Case was due to call on the 5th of July, when they would have to give some indication to the judge about how they were going to proceed in the case. And they were advised the witness resided in a particular town in Poland called Pila. They were able, through the Polish EJN contact point, to establish that there was a way to do this, which would be by video link evidence. Any request for a video link had to be sent to the court in Pila, but it turned out the court there didn't have a video link. So any link would require to be established at a more neighbouring court in Lodz. They got contact details for relevant persons in both courts, It allowed the Crown not only to advise on the 5th of July here their intentions, but also to prepare the necessary petition and letter of request and present it before the court on 5th of July. Now, that means that on the 2nd of July, the Crown Office was advised that there was going to be an issue with this witness. By the 5th of July, they were able to go into court in Scotland and say, well, we have resolved the difficulty that this presents, and we have been able to do so by the following means, and here's already the formal papers. Now, I think the Lord Advocate's view and the Crown Office's view on that sort of case is that without the assistance of the contact points provided for by the European Judicial Network, this wouldn't have been done, and it's unlikely that the information would have been available before the trial, let alone the actual preliminary hearing. And I think it's those sorts of things that people have a tendency to forget about, because a criminal, trial isn't just the circumstances that take place in the courtroom on the day. It's a whole set of small things that have to get you there. Now, I mean, obviously, you can maintain an informal contact. Absolutely, that's entirely possible to continue to do that. But it would very quickly become outdated, as you know. People change, people move. Just think about your own contacts here. How very quickly. The phone numbers have changed, or the personnel has changed, or the job title has changed, etc. And many EU member states, don't forget, have federal structures. And for anybody outside looking at the UK, they would have to deal with 2 different legal jurisdictions. So having a formal contact point in Scotland would be very important for anybody else looking at what we're doing. It also, I think. It means that you would be falling back on making ad hoc arrangements. There's no doubt about that. They'd have to be done on a bilateral basis, but it would be entirely then a matter of goodwill, which, given the UK opt-out, might not always be uniformly the case. And because the arrangements then wouldn't have the backing of an EU instrument and the structure it provides, I don't think there'd be the same incentive on the part of the other parties to actually maintain that and to keep it in good order. And I think for those reasons, and that's I think there's a tendency to think the European Judicial Network is just about people having natters to each other in chats. It's not. It's actually about very, very practical things that will require to be resolved from time to time, given the free movement of people throughout the EU. And I think it's important. It's certainly from the Lord Advocate's perspective, important that this be retained for Scotland. Now, if you wanted more information, it's probably better that it comes directly from the Lord Advocate. He would be able to give you even greater chapter and verse. But I think that's the position that he would be taking, and we would certainly want to support the Crown Office in their stance.
Well, certainly the Lord Advocate's letter to us says it remains the position that he wants to keep the European Judicial Network measure within those which are opted back into. So he makes it plain in his letter to us. Sorry, Roddy.
Could I just move on to kind of what's the important part, the transitional arrangements? I noted from the House of Commons EU Scrutiny Committee in kind of something that reminded me of the Article 48, Article 49 debate that we're having about Scotland and Europe, that the view of that committee was that the earliest date on which the UK may formally notify its request to rejoin individual measures subject to the block opt-out is the 1st of December 2014, whereas the UK government's position seems to be that they want a seamless transition and that therefore they have kind of started negotiations now. And their express view is if there is to be any gap, our starting position is we do not believe that there need be, but if there is, the government will work to ensure that the transitional arrangements foreseen under Article 10.4 of Protocol 36 are such that measures continue to apply to the UK during that period. I don't know whether the Minister or your team can just give us a bit more guidance on how we look at the transitional arrangements and how much of a problem the seamless transition is likely to be.
Well, we have some considerable concerns about it, and it's why, in a sense, we've shifted our focus really now on trying to ensure that transition is kept as smoothly as it can be. The issue, for example, of the European arrest warrant, which we've already discussed, arises, that even if you're going to go back into a reformed or changed system, the intervening period, if there is a transition, isn't going to be as straightforward and simple as people imagine. For example, some countries have effectively, well, you could revert to the previous more cumbersome extradition. Some countries have effectively ruled that out with their own constitutional changes. So you wouldn't, in every case, have another party who would be able to just revert in the same way that we are talking about. And I think the danger is that you would end up having to have a lot of temporary bilateral arrangements set up in order to deal with a transition in which there was a gap. So our principal concern is to try and ensure that there isn't that kind of gap. And I think it would be one of the things that we would be trying to impress on the Home Office Minister when she comes, that from our perspective now, the most important thing is for us not to have a period of time when there was that level of uncertainty and confusion.
From the letter you read, I didn't take it that the Home Office Minister was saying that she had kind of an unconditional agreement from 27 other member states. This wouldn't be a problem. It's just that she was discussing it. Is that right?
Well, I mean, we've had a letter, and the letter only came in at the end of last week, so we're not really in a position to be able to elaborate terribly much more than I already have, other than that we would clearly take up the offer of a meeting, and I think it would be important for us to do so, so that we could make our position quite clear as quickly as possible. Because we're not party to any of these negotiations, it is very difficult for me to make any kind of assessment on whether or not they can be achieved with a successful outcome by the time scale which would be hoped for. I mean, that's really information which is well outside my my knowledge.
What they have said, what the UK government has said, is that the process is complex and that there are a lot of technical and process issues that need to be resolved. They believe from their initial discussion with the other EU member states that there's a willingness to try and resolve this as quickly as possible and avoid a gap. But clearly the discussions are having to happen both with the EU member states and with the Commission itself. And it's not clear from our point of view the stage that that's actually reached and whether they've got assurance on particularly the point you raised of whether or not you can effectively have the opt-out apply from the 1st of December and then instantly opt back into the 35 measures. And that will be a key issue that we've been raising with officials, and the Minister will wish to raise with the UK ministers as well to try and get assurance on that.
Minister, you'd have no problem in sharing the outcome of your discussions with the committee so that we can monitor that. Yeah.
I mean, I it would. I mean, it would be for the committee to decide how they want to take this forward. As I said, we don't have a date for a meeting yet, so I don't know when she will be in Scotland. So, that's that at this stage. There's a degree of uncertainty about that.
Yeah, I'll just leave other people in. I've got John Finney, then Elaine Murray. John, please.
Good morning, An important role in any process is the parliamentary scrutiny, and this committee has expressed some reservations about timeframes around legislative consent motions, for instance, in the past. This particular issue has been looked at by 4 UK committees, and if I quote from one of them, the European Scrutiny Committee that Roddy commented on, the reluctance of the government to provide Parliament with the information it needs at a time it needs it in order to claim a proper understanding of the legal, policy and operational implications of the block opt-out, as well as procedures determining which measures the United Kingdom will be able to rejoin. Are you having any discussions about the broader issue of how the UK government engages with the Scottish government to prevent a repetition of this sort of approach?
Well, at a government level, that's rather above my pay grade, I think I would probably have to say. I mean, I'm in this portfolio, we're concerned with issues which relate to justice matters, and I think we've made our position quite clear in respect of this particular issue and our concern that we weren't really involved or consulted, and that's government to government. You know, it is very difficult for this Parliament, I suppose, to exert any kind of scrutiny function on an issue when the government itself is unclear as to what exactly is happening. And it's hard for me to advise the committee in those circumstances how to proceed, really, because I can only tell you what I know, and at the moment, what I know is not a huge amount.
Okay.
That's kind of, it's a difficult one for me to answer. I mean, I think there are scrutiny issues. They may be seen to be principally for Westminster initially, but of course, when it comes to justice matters, they're very important for the Scottish Parliament as well. And in a sense, we are sitting at some remove from where the decision-making process is.
I think it's fair to say that this is a one-off decision that is very different from the other arrangements, the ongoing arrangements that the Minister mentioned, where we do have engagement with the UK government about the opt-in decisions on the post-Lisbon Treaty measures. And in general, while there are always debates, there are fairly established procedures where we have that dialogue with the UK government and have a reasonable time to see what's coming down the track and to speak to them about that. This is a separate decision that's out with those normal arrangements.
There is an ongoing level of interaction between officials south of the border and north of the border, which would happen on a relatively regular basis. This is kind of elevated, if you like, a bit beyond that because of the nature of what we're talking about. So I you know, from the point of view of parliamentary scrutiny, if you're talking about Scottish parliamentary scrutiny, then you know, I think it would be for the committee to decide how best it wanted to proceed.
But this is pure politics at UK level.
Well, it's hard for me to answer whether it's about politics or whether it's simply their view that really is a decision for them, and on this occasion they didn't even see the necessity to consult. You know, we're concerned because obviously they know that there are two separate legal jurisdictions in the UK, and therefore decisions that are made at UK level ought to be taking into account the fact that we have two jurisdictions. In this particular case, that doesn't seem to be happening.
Sorry, I beg your pardon. There's no debate that the Lord Advocate and the police have made their position very clear.
Absolutely.
Of the downside of
absolutely, but as have we at ministerial level as well. So they are in no doubt what our view is.
I think it's fair to say there's been criticism from the four Westminster committees, from the Northern Ireland administration and from other stakeholders about the general handling and level of consultation and information around this specific decision around the opt-out.
Thanks very much, Convener. If I could return to the European arrest warrant, the Home Affairs Committee seemed to have been quite critical of aspects of it, and they stated, for example, that it was based on a flawed assumption of mutual trust in the standards of justice, and in other member states, and facilitated miscarriages of justice in a number of cases. Just wondered if the Scottish Government is aware of any cases involving Scottish citizens where there had been miscarriages of justice due to the use of the EAW?
I have no such information given to me about specific cases where we would feel that there had been miscarriages of justice applying to people from Scotland. I mean, I read the figures out to you, and obviously there are fewer folk who are being sent from here elsewhere. I mean, there was another case when I was looking at the cases and reading out some of the ones where we'd been able to go and get people here or deal with the scenario. There was another one where we were able to very swiftly send somebody back to Poland. I think Poland is the right, send somebody back to Poland very quickly when they were accused of murder in Poland. But we're not conscious, and I've certainly not been given any information from prosecutors or police or anybody else that they feel that the arrest warrants that they're receiving are in any way about trivial matters or are about things that they would not themselves want to take seriously. So that kind of issue is one, it would appear, of the big differences between north and south of the border. We're just not seeing that as being a concern. And the question of potential miscarriages of justice, well, I mean, whether you've got a European arrest warrant or not, that might or might not be an issue. Those issues would just as easily have risen under the previous formal extradition process. I mean, the questions of miscarriages of justice are ones which bedevil all of these processes, regardless of whether it's extradition, European arrest warrant or anything else. I don't think it applies particularly to the European arrest warrant in perhaps the way that kind of reading suggested. So it's just not our experience that any of this actually applies.
The report also suggested that the EAW could be improved from within the current framework directive. Do you think there's a case for that being done? Do you think that's possible? Do you think there's a case for that?
Yes, but I'm assuming that is the case. I mean, I haven't looked at the technicalities of the EU processes for doing it, but it would have been our preference to have done so from within the framework. So that would have then avoided the difficulty of potential gap. So, it's a very clear and distinct difference of approach and opinion on this.
Thanks.
And just to remind me, Minister, it's European arrest warrants only used for indictable offences, I would imagine. Is it for just crimes to the High Court? Is it, or is it?
It can be for a wider set of crimes, but the case has to be made.
But it's for lower level crimes as well than High Court crimes.
It can be.
Yes, just from my own thought.
But the information that we have is that it's relatively rare to get a European arrest warrant for anything that would be considered very trivial or low level.
Yes, so it's serious offences.
Yeah. I mean, it's not to say that it won't happen occasionally.
But basically, broadly speaking, very serious offences. Christian, followed by Sandra.
Yes, good morning. Thank you very much, Fiona. Just reading the Lord Advocate comment, I would like to have some of your comments on what he said about this gap, this transition gap. He's talking about a fear that there will be a cost attached to it. I read that under the Lisbon Treaty, the UK would be required to meet the cost of any financial implications to member states. Is there going to be a cost attached to Scotland as well?
Well, we're making it clear that if there is a cost that relates to the potential transitional changes, that is not a cost that should be borne by us, since it's not our decision that we're in this position, and it is not a position with which we agree. Beyond that, I can't really kind of elaborate. I don't know if the officials are aware of anything more detailed on that, but I don't. I mean, yes, there may be a financial cost because we would have to bear the cost of the transitional. The UK would have to bear the cost of the transition, but from our perspective, we would resist very strongly any attempt to apportion a cost to Scotland, given that we neither asked for, wanted, nor agree with this particular move.
The UK government hasn't provided a financial analysis of what the implications of different options might be. What they have said is, at least officials have said, is that they don't believe there will be significant financial costs associated with the measures that they are opting out of, as opposed to the measures they hope to opt back into. Whether that position would change if there was any gap and any significant difficulty around that, again, we've not had clarity from the UK government around that yet.
Yeah, it seems to me that reading the observation of Lord Advocate is not only the cost to the UK, but we'll have to take the cost of the other member states as well, which is very difficult to know what we could be. Another point as well, the Lord Advocate said that this transition period could be a real problem and it will be keenly felt with the Republic of Ireland have we got, I would understand between the Republic of Ireland and Northern Ireland, but is Scotland in this case as well? Is there a lot of cases between Republic of Ireland and Scotland?
I don't think I've got specific cases that relate to other specific jurisdictions. I think the Republic of Ireland is one of those member states that has replaced the previous Convention on Extradition with the EAW. Therefore, the Republic of Ireland would be unable to revert to, they would have no extradition process to revert to if there was a transition. So Ireland would be one of the countries that there would really require to be a temporary bilateral treaty in order to cover the transition period. And if there is a transition, then that would be necessary. And I don't know at the moment. I don't know at the moment whether or not there is a discussion about drafting a bilateral treaty at the same time as we're progressing, or whether or not that will only happen if we end up in a transitional period, in which case the transition would still create a gap. And that will be of particular concern if there are any live proceedings on in either place. I mean, anything that was a live proceeding that got caught in this transition, there might be an issue there.
Thank you very much, Convener, and good morning, everyone. I think we've heard about the lack of consultation and talks between the UK Government and the Scottish Government, and obviously even the House of Commons Select Committee, etc., not happy at what's actually going to take place. But I wanted to touch on a couple of comments that Police Scotland made, and perhaps bring to Christian what he had raised about costs. Now, Police Scotland says that if we don't go ahead with this, law enforcement agencies, the impact on the operational effectiveness of the law enforcement agencies, and it would place our communities at an unacceptable level of risk. Now, I'm pleased that the Minister had mentioned the fact that UK Minister is going to, Home Office Minister, is it Caroline Bradley, is going to come up, but we don't have a time scale or a date for that. We don't exactly know what's going to happen. But to come back to the fact about placing our communities at an unacceptable risk, you did mention how quickly warrants could take place, European arrest warrants, particularly one in a couple of hours even. What are the risks to our communities if we don't manage to go forward with this in a transitional period seamlessly, the European arrest warrants?
Well, I mean, if you can't go forward, I gave some evidences where there was the ability to actually move very quickly. And in one case, the assessment was if they hadn't had that ability, they simply wouldn't even have had that evidence at a trial. So arguably, one could say that without the ability to move as quickly as that, there will be trials that either proceed without all the evidence that was necessary, and then who knows what impact that lack of evidence would have. And that's before you even talk about whether or not you can get the accused into court. So, anything that impedes the proper and speedy administration of criminal justice then is a concern. I mean, in most cases, whatever the criminal activity is will have already taken place. So that aspect of it is done. The question then is whether or not you can take the subsequent measures in respect of an accused and all of the witnesses to actually make that aspect of the criminal justice system work effectively. And I suppose what the Chief Constable is saying, as is the Lord Advocate, that actually that part of the process won't work as effectively if we don't have access to the European arrest warrant and, indeed, in their view, the European judicial network as well.
Thank you, Convener. Just to pick up on the type of crime, I mean, obviously at the moment, the horrific crimes of human trafficking at the moment, and Mr Rennick says that it would apply to various aspects of crime, if not all crime. Would it have an effect on bringing people back who have trafficked folk in? Would it have an effect in that? We couldn't.
I mean, if we're in a transition period and somebody goes to Ireland, then the capacity to bring somebody back from Ireland is going to be extremely made much more of a problem than it would be under the European arrest warrant, and that you know, it's kind of you know, depending, and that will depend from jurisdiction to jurisdiction. In some jurisdictions, a bilateral transitional arrangement might be an easier thing to set up, but Ireland is one of those countries that has effectively expunged the previous extradition arrangements from its constitution and operates entirely through European arrest warrants. So, you know, you're then in a position where, for jurisdictions such as Ireland, a transition does create a big concern, and therefore, presumably, you would have to be talking about bilateral treaties to cover a transition period. But how that process will work, I don't know. How long that process will take, I don't know. Whether it's actually achievable within the timescales that are required for it to achieve, I don't know. So is there the potential for there being a kind of breakdown? Yes, you would have to say there is the potential if we can't get this sorted in the timescales that it requires to be sorted.
The two risks that police here in Scotland and down south raised around particularly the European arrest warrant were that you wouldn't be able to obviously bring people back from abroad who had committed crimes here, but also obviously there's a danger that you would have foreign criminals potentially accused of very serious crimes at large in Scotland who you wouldn't be able to quickly identify, arrest and send back to the country where they committed that crime. So there's a double risk of undermining justice here, but also having people who are undesirable within Scottish society until we can find an appropriate procedure to send them back.
Just a wee tiny follow-up, Chair. So all the good work that's been done...
I like the way you do that.
Yes, just a wee tiny one. All the work that's been done with agencies working together, particularly to do with trafficking, that could all fall apart if this transition doesn't happen in time.
Well, I mean, if there is a gap, then it will affect anything and everything that's caught in that gap, from high to low level crime. From, you know, and would that include human trafficking? Well, yes, but I mean, you know, the gap is the problem. It will, I mean, if there is a serious gap, then it will affect all cross-border crime, and to a greater or lesser extent. You know, in some cases it might not be such a big deal. In other cases, it will be. I just wanted to kind of talk about another issue as well, which kind of relates to this, and that's the criminal record exchange system that is set up, which is extremely important. It's a system that interconnects the national criminal records databases of all EU member states. Now, given the flow of movement now around Europe, that's extremely important. And people might remember when we were discussing the issue of disclosure certificates, how we were going to manage that process when we will have people who come from lots of different parts of Europe. That's extremely important, not just for the disclosure, but for providing complete criminal records for individuals who are charged and then convicted and sentenced, because sentences often flow from the level of previous convictions that somebody might have. You know, for example, there was a Latvian male charged with drink driving offences in Scotland, but his criminal history check revealed convictions for various offences, including rape. So, although he was picked up for drink driving, when it actually came to getting the information about his previous convictions, it discovered that a conviction for various offences, including rape, which meant that he could now be put on our registered sex offenders list. So, you know, these things are often interlinked, so that when you're talking about the safety of the public, it isn't just about the arrest warrant and the progress of criminal court cases. It's also about other aspects, such as the criminal record exchange, which, from the point of view of safety of people here, is very important too. I mean, it is obviously very important for us to know if there are people who are sex offenders, they should be on our sex offenders list. And removing that capacity to exchange that information is going to create a situation where there may be people who are out and about in our community that, you know, we don't know about, that we should know about.
Just ask you then for clarification as to the criminal, which seems very important, it is very important, criminal record exchange. Is that linked to the European Justice Network? No.
No, that's
Just
actually
I want to know how it fits into...
Yeah, that's another one of the you know, we've talked about the 35 opt back in and all the rest of it. That's another one of the ones that we're having to opt out of, and then we're talking about opting back in. So you're talking about the gap again.
It's a gap.
Yeah,
The
it's a
government
gap
is
again.
minded to opt back in on that,
Yes.
but not the European
Yeah.
Justice
So I
Network.
think
that's the one that's out.
Yeah, the European
Fine.
Justice Network, Judicial Network, is the one that they don't want to opt back
I
into at
understand,
all.
yeah.
But there are it's more than just, we were talking about European arrest warrant, but
there's other things, I
when Sandra White asked about safety of the public, it isn't just about the European arrest warrant. I think the point I was making is that you introduce a gap. It's not just the European arrest warrant. You introduce the gap.
Criminal records.
It's criminal records exchange as well. So, you know, those things all have the capacity to impact on public safety.
No, I understand. It was just
Okay.
to clarify.
No,
where
it is
was in
quite.
relation
It's very
to justice.
technical.
No, I
obviously.
followed it. I followed it. We've all followed it. So we are quite sharp as tacks here. Margaret, followed by John Pentland. Margaret.
Good morning, Minister.
That's interesting.
I wonder, could you explain then how you think this could be handled better to try and avoid any gap in the transitional arrangements? Or avoid transitional arrangements?
Well, avoiding transitional arrangements will require the UK government to have everything agreed so that when the switch off happens on one day, the switch on happens the next day. And my experience tells me that that's unlikely to be as easily done, because that would have to be a December 31st switch off and a January 1st switch on. And I'm guessing most people might be sceptical as to whether or not that could be arranged in all of these. That's our concern. But that's our main concern now, is to actually try and do what we can to help ensure that that does happen, even if we are a bit sceptical as to whether it can happen. That we should do it. We should make every effort to make sure that it does happen. And the bottom line is that means that if you are talking about any gap, that gap has to be as minimal a gap as possible, because the longer the gap is, the longer the transition period it has to be dealt with, the more problems are likely to arise, and the more likelihood that you are going to have to the kinds of things occurring that we've been discussing here. But I'm not in the driving seat on that one. And it's not going to be a matter for me as to whether or not that happens expeditiously. And I think it's important that we all, if you like, bring as much pressure to bear to ensure that it does happen as expeditiously as possible. I mean, our preference would have been not to do the opt-out in the first place, because the defunct and you know, frozen measures, they're defunct. I mean, they're gone. They're like the bits of legislation that lie about from the 15th century. That, you know, there is a phrase we use, which is, you know, law that's gone into desuetude, which basically just means it's no longer you know, practice. I mean, effectively, that's what this is about. But in order to actually go through a process of expunging those pointless bits, you're having to opt out the entire thing and then opt back in again. It's a very cumbersome process. And I think our view would have been, look, it would have been much easier just to have not done the opt-out in the first place and just allowed these things to die on the vine.
I understand there's no option, that the European Commission said it must be an en-bloc opt-out. And in that en-bloc opt-out, then you've referred to, I think it was the 43 defunct measures, but there's also 52, which I take it the Scottish Government is quite in favour of opting out of. Would that not have put these measures back in, and we'd have to be trying...
We saw nothing that gave us concern about that. The UK government wasn't forced to opt out. It was basically a position where, if they wanted to opt out of some of them, they had to opt out of the whole. So they could have chosen not to opt out. Yeah. What they've done is choose to opt out of the whole and then negotiate opting back in of a certain number. Now, there were others that we might have made a stronger argument about, but we are where we are. I mean, there's no point us continuing to make arguments about others that we would have felt we should have retained. The principal big one that isn't going to be opted back into, that we think is of real value, is the European Judicial Network. But that's more just the practical politics of where we are now. It doesn't mean to say that there weren't others that we wouldn't have argued about had we been involved early on in the discussions.
Yeah, I understand that, Minister. I think you made a strong case to be put to Karen Bradley on your position in that. Can't we take some comfort, though, in that it's not in anyone in the UK's interest, or indeed the European Union's interest, that there should be this gap in the interest of establishing effective policing and the criminal law? Well,
obviously it is in nobody's interests, and we assume that that's what's behind the express determination of the UK government that that will be achievable. I'm merely expressing some scepticism because it's quite a challenging time scale to be looking at across all of these opt-outs. You know, if we achieve a December 31st switch off followed by a January 1st switch on, then that will be a fantastic achievement. If we don't achieve it, I can't say I'd be horrendously surprised. And it therefore becomes an issue. That's why the gap, the transition issues are very important. But they're important to emphasise the problems that would arise, because by keeping those issues to the forefront, those transitional problems to the forefront, then we further encourage the speedy resolution of the issues, and we hope that gives some impetus to ensuring that this is all done in a timeless manner.
Could I just check the timescale? I think the UK government was going to make its position very clear early on, before the deadline for opting out, so that these discussions could come in. Could you just outline the timetable? December didn't sound...
The UK was required to take the decision 6 months before the pre-Lisbon measures come under the jurisdiction of the European Court of Justice and therefore the Commission. So that's the 31st of May this year they had to take the decision by. In practice, they indicated their initial view in October 2012 and then formally confirmed their view in July 2013. So they have the Prime Minister has written to the Council and confirmed that they will be opting out. So effectively they've already taken the decision to opt out that they had to take by the 31st of May, and now that will then take effect from the 1st of December. And the issue is clearly whether or not you can opt out have the opt out apply on the 1st of December, but instantly opt back into the 35 measures, and that's clearly the hope of the UK government, that they're able to negotiate, establish a process that would allow for that, and then B, negotiate agreement with the Commission and with all the other member states that can go ahead.
Yeah, I think it's the UK government's kind of lobbying and negotiation. Have we looked at any of our Scottish MEPs to make them aware of the importance of this, so that they too are in any available opportunity, sort of cognizance of this, and making Europe aware that it's no one's interest to have any gap?
I think this is ministerial level and commission level rather than.
I know that some MEPs are particularly aware of the European arrest warrant issue, and I don't, as a government, we wouldn't take it upon ourselves to advise individual MEPs. I mean, I think that would be something that the parties probably ought to do themselves.
Now we've explored the gap in transition. Is this a different thing, John? No, I don't feel you don't need to ask about it, but.
Oh,
exhausted the gap.
I'm getting gapitis,
No, my question is probably a purely simple one, Minister. You did say that obviously this is a very, very technical report, which probably allows me the opportunity to ask a kind of hypothetical question in regards to a scenario which probably won't happen. If Scotland had to be independent, if we assume that Scotland's to be independent after in September, vote in September, And if we assume that Scotland will automatically become part of the European Union, well, we have to come back here and renegotiate.
I suspect that interesting. Though the question is, I'm going to let that, as you say, stick to the wall, because I don't think that. It's up to you, Minister, but I don't think it's something required to answer.
In the first place, you would be talking about 2016, and because until 2016, regardless of what the vote was in September 2014, until 2016, we remain represented by the UK government in Europe, and therefore these discussions. I mean, the 18th of September, doesn't. A yes vote on the 18th of September doesn't change these discussions and doesn't change the problem of the gap, because regardless of what the vote was in September, the gap is still a potential problem for us in a shorter and medium term than into the slightly longer term that a post-2016 scenario would arise, would give us. And I do have to always caveat that by saying, a lot would depend on who was in government in 2016 in an independent Scotland, because people will have, different parties have very different views about their interactions with the EU. And, that would be a matter then for that first government to decide.
I'm going to put this question to you because it hasn't been put to you. There hasn't been a question put to you from the submission by the... Oh, I beg your pardon. I beg your pardon, John.
Can't talk about a gap. I can't talk about anything.
No, I just think we've exhausted
no, my question, even though it was a sort of tongue-in-cheek question, there was a bit of reality and genuine about it, because it did say, in the report here that, that member states, since 2009, the rules were changed, and member states will no longer have the opportunity to opt out because effectively they cannot reject the full jurisdiction of the Court of Justice. So it was asked with that. The question was asked genuinely, and that's the point I'm trying to make, that in 2014 you'll no longer have that option to opt in or opt out.
Well,
is this what I'm reading here, or perhaps it's too technical? I'm not
No. 2014 is only when the vote. Until 2016, we remain under the arrangements of the UK government's participation in the European Union, and everything that happens until that point, will come from this discussion that we're having today. Post 2016, all I would say, if the member's question is tongue in cheek, can I just tongue in cheek respond by saying I'm glad he recognises that Scotland would be a member of the European Union in 2016.
Minister,
sorry, John.
Minister, at this start, this was a hypothetical scenario.
Well, there you go.
I just want to finish again, if that's okay, John, if you finish your little foray there. The Law Society of Scotland, because nobody's asked about this, had actually said, and it was touched on by Margaret Mitchell, Law Society says they believe that the opt-out should not have been exercised. Then the quote from the Centre of European Legal Studies working paper quotes opting out of EU criminal law, what's actually involved, close quotes. And then they go on to say from that, the UK's withdrawal from these instruments would seem to send a negative message as regards to the UK's attitude to law and order and international efforts to further it by withdrawing from them. The UK would appear to be telling other states, other member states, and indeed its own citizens and the rest of the world, that it considers the forms of antisocial conduct they are aimed at, terrorism, money laundering, people smuggling, cybercrime and so on and so forth, are not so grave as to require international cooperation to deal with them effectively. Now, that's just a quote. I'm not saying that's my position, but would you like to comment on that? Do you think that by opting out, that there is, where there's apparently good relations, particularly formalised to the European Judicial, I keep forgetting its name, network, that there's a kind of message being sent that that cooperation and that joint serious attitude to what is very moving crime now in serious organised crime across member states and across to Scotland is somehow being jeopardised, that culture of help and assistance?
Well, I think that probably lies behind why we felt that the opt-out shouldn't have been exercised in the first place, because where the opted-out measures were of no further practical use, it made no difference. But we were effectively coming out of cooperation for certain things that were going to, that were continuing to be useful and helpful. And then going through an entirely artificial process, if you like, of then having to argue to opt back in again. I can get drawn on the politics of it. I think this was probably to give a political hit about opting out of EU measures and the officials will just have to close their ears at this point, and making a kind of virtue of the fact that this was being tough in terms of UK government stance in the EU. But in practice, you have to opt back into all of the practical stuff, because if you don't, then you create big problems. And I think that what we've now got is the consequence of what may have been a political stance in the first place, but the reality is now having to handle the practical downside of that decision. And I said at the outset, this is not where we think we should be. But unfortunately, willy-nilly, it's where we are now as well because of UK government decisions. So we've just got to get on with arguing what we can argue within the confines of that decision that has already been made, which is why we've only focused on the European Judicial Network, not gone over all the other things that we might have gone over, because there's no practical point to doing that now. We will continue to make the argument about European Judicial Network and to focus very much on the transitional period, which we think is going to be the most important thing now.
I think that's a good place to stop. And so I'm going to stop right there, and I'm going to have an 8-minute break. Well, take it up to 11:10 because the Minister's back. So we'll suspend until 11:10 and we do the next item on the agenda. Thank you. Thank you. Back to the grindstone. Item 3, Offensive Behaviour at Football and Threatening Communications, Scotland Act. It's an evidence session on the operation of that bill, or that act, I should say. The Minister is staying with us for this evidence session, but her officials have swapped over, as you can notice. I therefore welcome the meeting with the Scottish Government, Tom McMahon, Head of Community Safety Unit, and Jerry McLaughlin, Head of Community Safety Law. Welcome to everybody. And Minister, I understand you wish to make an opening comments before I open up questions to members, please.
Yes, I do. Thank you, Convener. I think it would be helpful for us to reflect on the background to the Act's introduction. Almost exactly 3 years ago, the Celtic versus Rangers Scottish Cup replay on 2nd of March 2011 featured a number of incidents on the pitch and 35 arrests for a variety of sectarian and racial breach of the peace offences within the ground. Following the match, Strathclyde Police reported a sustained increase in the level of violence and disorder. And this, coupled with a pattern of increased violence and disorder at the time of Old Firm games, resulted in Chief Constable Stephen House requesting a meeting with Celtic, Rangers and the Scottish Government to address these issues. The First Minister convened a football summit on 8th March 2011, which brought together representatives from the police, football's governing bodies and Celtic and Rangers football clubs, and resulted in the formation of the Joint Action Group. Also in March 2011, Neil Lennon was the target for 2 parcel bombs. He had also received live bullets through the post, as did some Celtic Football Club players. Viable explosive devices were also sent by post to others associated with Celtic Football Club. Trish Godman, MSP, then one of the Parliament's deputy presiding officers, and the late Paul McBride QC, who had represented Celtic Football Club. And in May 2011, Mr Lennon was attacked by a Hearts fan during a match at Tynecastle. And that then was the background to the introduction of the Offensive Behaviour at Football and Threatening Communications Scotland Bill on 16th June 2011. I thought it was just important for us to remind ourselves of what that period was like, because it is too easy for us to forget how fevered and how difficult things were. We made clear when we introduced the Act that it would not be the only thing this government would do to tackle sectarianism. And since then, as members know, I've appointed an independent advisory group on tackling sectarianism in Scotland who published their findings in December. And I've also announced over the period a total of £9 million investment in tackling sectarianism. And on Friday, just last week, as it happens, coincidentally, we published the Scottish Government's response to the report of the Advisory Group on Tackling Sectarianism. And I just want to say 1 or 2 words about that just now. The Government response acknowledges that the Advisory Group's findings on the complexity of sectarianism in modern Scotland, which highlighted that sectarianism remains an issue that needs to be dealt with. The Advisory Group also felt that there was a real appetite for change and that communities in Scotland are tired of the worn-out rhetoric of sectarianism and the impact it is having on people's lives, and I concur with that view. The Advisory Group made a series of recommendations which went beyond the Scottish Government and included local authorities, football clubs and governing bodies, march organisers, churches, the media and educationalists. I've written to key stakeholders highlighting recommendations that are relevant to their interests and asked them to consider these. And I've also extended the lifespan of the Advisory Group to the end of March 2015, which will ensure that they are able to give us independent advice on collating and interpreting the information and evidence we are collecting. The Group's report made clear that they wish to see sectarianism addressed in the same way as racism and homophobia. While it predated the Group's report, the Offensive Behaviour Act reflects that approach as it deals not only with sectarianism, but the full range of offensive behaviour at football which can give rise to a risk of public disorder, and that includes racism, homophobia and other hate crimes. For that's the broader context we need to be conscious of. Any form of attack or discrimination based on someone's actual or perceived disability, religion, race, etc. is completely unacceptable. And that's why we've launched the Speak Up Against Hate Crime campaign just last month. And just in closing, Convener, just this weekend we heard about the alleged racial abuse of a young East Stirlingshire player at a match against Peterhead. I'm pleased to learn that Police Scotland are following up on positive lines of inquiry and that Peterhead are assisting police with the identification of the people responsible. The reporting hate crime will help tackle the abuse, send out a clear message to perpetrators of the unacceptability of their actions and work towards preventing acts of hate happening to others. And the message of that campaign echoes the conclusions of the advisory group and is the same message that this Act sends out in a football context, that Scotland is a country which does not tolerate any form of prejudice, discrimination or hate crime. Thank you.
Thank you very much. I just want to say to members, before you ask questions, you have in your papers the case of the PF against Jordan Robertson, and that, of course, is sub judice, so you can't go into specific cases. But the clerks will keep me right in that. You know, you took up the general things, but not specific cases, unless, of course, they're completed. And that one isn't. Okay, questions, please. Sandra?
Thank you very much, Convener. I think the first time I've ever been first out with a question, but I suppose it's quite apt.
Not my fault.
No, I'm not blaming anybody. I'm just surprised. I suppose it's quite apt actually, because the Minister had mentioned the fact about the independent advisory group and basically the government's response to it. And I noticed that funding has just been released of over £860,000 for projects to tackle sectarianism in response to the advisory group report. Could the Minister perhaps let us know or tell us what groups will receive this and what remit they will have, if there is a remit as such coming from the advisory group, with the money of over £860,000?
If the member is talking about the most recently announced set of... This is not the most recently announced one. Okay, I can give you I think to be clear, I can give you an overview of the, in total, 44 projects, or I can talk about the ones that we most recently announced last week. I'm not quite sure what you would... The ones that was announced last week.
Minister, if that's all right.
I don't have the immediate details to hand. I know that there was a significant amount of money given to Citizens Theatre to put on plays and workshops that relate to sectarianism. I also know that the Deaf Connections has been given money to assist them in some of their work relating to this. There were 8 projects, I think it was 7 groups and 8 projects. One particular group got money for 2 separate projects. But I can let the member know in detail who they were. That totalled about £860,000, and that was just last week. But obviously there are a lot of others that are ongoing at the moment as well.
Thank you. In regards to the groups, you mentioned Citizen Theatre. In regards to education, which is obviously part of the report and working with local authorities in education, would it be the aim of the groups that receive this money to either go into schools and talk about it, or would the education, the schools, have some money from this?
Not all the money, not all the funding relates directly to particular schools and education-related things, because obviously there's an issue in the wider society. But clearly, for obvious reasons, quite a significant number of the projects which are requesting funding do relate to schools and education. Education Scotland itself has got materials that it's working with. I mean, it's obviously a theme throughout a variety of different projects, but it's not the only thing that is funded. The £9 million obviously covered a huge variety of different things. But the key organisations, I think, in respect of education, apart from the work that Education Scotland itself is doing, the key organisations that have been funded in connection with projects that have to do with education are the Aberlour Trust, Iona Community, Royston Youth Action, Sense Over Sectarianism and Nil by Mouth.
Good morning again, Minister. I'd just like to ask you a little bit more about the advisory group's report and your response to it. The advisory group have made some quite important proposals in relation to football in section 6.73.1. You rightly say it's obviously for the football governing bodies to take forward, but how far can you as a minister assist the advisory group in at least drawing these recommendations to the Football Association's attention?
Well, I have in effect already done so, because when we responded to the advisory group report last Friday, we wrote, well, not just to those involved in football, but we wrote out across to all of those institutions that the advisory group did have recommendations for. I mean, we responded directly to the recommendations which were for Scottish Government, but what we did was write out with a copy of our response to all of the others, inviting them to also respond to the recommendations which were directly for them, and suggesting that June would be a good time for them to have a response by. So we have sent a copy of our response and that covering letter to both Celtic and Rangers, but also to the football authorities, so that they can make sure that all of the clubs within their various organisations are also advised of this. That's from the point of view of our published response. I mean, I try to keep a reasonable distance between myself and the advisory group. We set it up as an independent advisory group, and it wouldn't really be for me to be, sitting in with them every other week, kind of telling them what and what they shouldn't do. But what we are trying to do is to encourage as wide a range of institutions as possible to respond to any of the recommendations that the advisory group flagged up for them, and that does include the football clubs and the football authorities.
As far as the University of Stirling's research on marching, have we any idea as to when that research is anticipated? Be concluded?
Tom, do you know when the research on marches and parade stuff?
Research is due before the summer.
Right. Okay, thank you.
Yes.
Thanks very much.
A question I'd like to ask is on your, just think what it is, it's your response, yes, at paragraph 5.3, the need to develop a working definition of sectarianism, embracing all forms of it, and I think that's an interesting development. In that, I'm looking at the report from Religiously Aggravated Offending in Scotland 2012-13, in which, I didn't know about this, Islam, 57 anti-Islam charges, an increase in charges referring to Judaism. And so I think that's an interesting development, instead of polarising the debate, looking at it in a much broader way. Perhaps ask you to comment on that.
Well, I think the comment I would make, in a sense, is what I was trying to say in my opening remarks, which is that while the focus in terms of this legislation tends to be on one very narrow aspect of it, the reality is that it covers a great deal more than that, and it does allow us then to start mapping other things, such as the anti-Islamic hate crime that is in and around football, and the expressions of anti-Judaism, which some people might be surprised to see, but nevertheless which are being picked up now. And I think it's important that we know about these things. It's depressing to see it, but it's important that we know about it, because if we don't know about it, then we can't actually start thinking about whether or not there's anything that we can do about it. I have to say that you need to be just a little careful, though.
I saw that. One incident.
One incident,
yes,
and 57 anti-Islam charges, and I think we all remember the incident. I think it came out of a EDL march or a SDL march or whatever they're calling themselves when they march in Scotland. So so as with statistics, one always has to be just carefully. A little careful about what we're looking at.
Thanks, Convener. I think one of the important conclusions really of the advisory group was the need for leadership within Scottish society. That, I think they put it that there had been a tendency to avoid the issue because it's difficult, rather than to provide the sort of leadership which makes it clear that this sort of behaviour is unacceptable. And there's a whole load of they list a whole load of organisations, including obviously the football clubs and so on, that need to provide that sort of leadership. I just wondered what sort of contact you've had with football clubs in terms of some of the concerns some of the clubs or supporters might have expressed about the way the legislation is acting, because it could be counterproductive if the legislation appears to be what does the job rather than the leadership being provided by all those in society need to provide the leadership rather than just say, well, don't do that because you'll get arrested if you do.
Football is part of society, and I think the conclusions of the advisory group were basically, look, you know, civic society really does have to get into the driving seat on this, and that has to be across the board. And I think they said no government can do this on its own. And, you know, we have previous governments in Scotland who've also had runs at this. It is a very difficult and challenging issue. There is no doubt about it. But that, you know, the fact that it's difficult and challenging doesn't mean to say that we shouldn't make a serious attempt to do so. In respect of the football clubs, I mean, there was a period of engagement, particularly when the Joint Action Group was still in action through 2011, probably into 2012, when there were regular meetings between us, the football authorities, and some of the key clubs. So that went on for quite a while. It wasn't a one-off in 2011. It was a continuing process that went for quite a while. Subsequent to that, I've responded twice to requests from Celtic Football Club for meetings, and I have in fact met representatives of Celtic Football Club twice. I'm not conscious that Rangers has asked at any point for a meeting with me. So, but I do know that, for example, they've recently met with the advisory group. So, you know, there is a conversation. It is still going on. There are other, of course, you know, with some of our football clubs and some of the football authorities, there have been other things that have taken their attention onto bigger issues. One can see with Rangers that their attention has been diverted into a rather different debate. So, you know, we are often at the just as much in the hands of people who are potentially partners. There is a football-related disorder and safety group which is meeting next week, and Tom McMahon is actually chairing that. That's being dealt with more at the officials level, and the SFA and SPFL are both involved. So I don't know whether or not you want Tom just to say something about how that operates. Tom?
Thank you.
It's on.
It's on. That's an ongoing group that involves Police Scotland, the SFA, SPFL and Scottish Government officials, and it's to progress the various actions that emerged from the JAG. But part
Joint Action Group, yes.
And part of yes.
We've got to remember we're not officials here, so all that jargon goes past us.
We'll specifically be discussing the expert group report and what the implications are for football. I met with Neil Doncaster and with SFA representatives late last year, and it's an ongoing dialogue that we have with them. So we've got good, effective links across government between ourselves on the justice side and also sports colleagues, and obviously the Minister for Sport as well has that as part of her engagement with them. But it's a formal part of our discussion now, the action that they need to take around sectarianism.
I'm sort of wondering about the contact with supporters rather than just with clubs, because obviously it's from supporters that some of the concerns about the operation of the legislation have come. So I just wondered what sort of contact there has been to discuss maybe their perceptions of the way in which the legislation acts, and also how that then feeds into a more general issue around attacking sectarianism more generally.
I would only mention briefly the research which has involved an online fan survey already that was conducted last September. There will be another survey after the current football season, and that will, obviously that's what we're discussing today, but that will be part of the evidence base that we'll base our review of the legislation on.
Can I also just say, and you know, I'm aware that Focus, which is the police kind of group that deals with this, does engage on a regular basis, not just with elected members, but with supporter groups, fan liaison staff and individual members of the public to answer queries and provide education. So Focus is also doing this. And I mean, obviously, an awful lot of the issues that arise tend to arise around the policing operations, the actual operation of policing. So it is appropriate, I think, that Focus be continuing to do that on a regular basis. I mean, I don't have a direct control over operational policing, but it's Focus that really are key to that. I think I'm right in saying it's still Bernie Higgins who's still the ACC in charge of Focus, and I know he's in, and Focus are in regular contact. So, I mean, in a sense, there's quite a lot still going on. It doesn't all happen just at ministerial level. I mean, there's a network of interactions and engagement taking place consistently, you know, there are occasions when, at a ministerial level, we are involved, both myself and Shona Robertson, and a lot of the time we're not directly involved in those specific meetings which might be going on between officials and others. And obviously we're not involved directly in the Focus work either, because that would be inappropriate.
Thank you. Alison, followed by John Failey, followed by Christian.
The Minister will recall that I was not...
Your light's not on.
The Minister will recall I was not supportive of the legislation in itself, but I must congratulate you on the setting up the advisory group, and I think you've moved the thing on very significantly, and I think the work that that group has done is to be highly commended, and I hope that we can all show some leadership and helping that go forward. But if I can return to the bill and to the Act, the committee's received quite a bit of correspondence from some fans, and rightly or wrongly there's a sense of grievance that's been fostered by the bill to some extent. You'll remember in committee here we had lots of discussion about whether or not you could be prescriptive about what should be sung and what shouldn't be sung, and I don't think we need to go back over all of that. But when we look at the analysis of the charges, 41% of the charges have been about singing, and I wondered whether or not, in light of that and in the absence of prescriptive list of songs, whether you've considered giving football clubs and supporters any further guidance or information which would enable them to understand the legislation a bit further.
Well, I mean, the 41% about singing is because that's obviously a method by which the offensive behaviour can be manifest. The Lord Advocate has published guidelines which do give quite clear guidance. I mean, there are very good reasons why we haven't, provided a list of songs. But songs can be changed, words can be changed, new songs can be developed. You would be in a constant cycle of catch-up trying to deal with it on that basis. But the Lord Advocate's guidelines, the published guidelines, which are there for anybody to actually have a look at, state quite clearly that the singing of songs and chants or the display of banners that are clearly motivated by hatred, and that can be on any of the grounds that are in the Act, will be caught by this offence if they're likely to cause public disorder. And remember, there's always the two halves. It's not just the offence, it's the public disorder as well. And it's a matter for the judgment of a police officer at the time of the commission of the offence. He's got to think about the nature and words of the song, including anything that's not standard vis-à-vis the song, or anything that's been added on to the song. So that's why, prescriptive list of songs would just be really difficult. And the surrounding circumstances. I mean, it's back to what we always say with criminal law, which is facts and circumstances, to determine whether or not that's what's happening. And the following, and the Lord Advocate's guidelines state that the following are examples of the types of songs and lyrics which are likely to be threatening or express hatred. 1, songs, lyrics which promote or celebrate violence against other persons' religion, culture or heritage, and songs, lyrics which are hateful towards another person's religion or religious leaders, race, ethnicity, colour, sexuality, heritage or culture. The singing, because singing is a mechanism by which in these mass gatherings offensive stuff can be expressed, then the breakdown of the method of abuse by singing just tells us that that's the mechanism by which it was used. It doesn't really tell us anything more in detail about the what and the why and the where.
Yourself that you believe that the policing in relation to the Act is proportionate and even-handed?
Well, I haven't. I'm not directly involved in policing matters, so I have to. I've got to consider that that we've passed the legislation. The legislation itself doesn't carry anything within it that that is about policing or relates directly to policing. And I've not, seen anything that suggests to me that what is happening is disproportionate. I mean, there hasn't been, there weren't thousands of arrests. And I think when the legislation was first being discussed, there were kind of conversations and discussions and debates, about that we were going to end up with thousands of people arrested, and that simply hasn't happened. And it hasn't happened for very practical reasons, of course, which you would understand in terms of policing. I think you had a letter from the Chief Constable when you asked the Lord Advocate, myself and the Chief Constable all to respond by letter. I think you had a letter from the Chief Constable which made clear his views. I don't want to start paraphrasing his letter because obviously his words are his words, and I'm not conscious of anything that I would feel personally as Minister that would contradict what he has said.
Thank you.
Perhaps have a supplementary to that?
Yes, unless, John Finney, you're on the same thing.
Well, Minister, we recognise that obviously it's an operational matter with regards to the police not being part of that. Can I ask you directly, have you had any meetings with this Chief Constable in regard to the view of the operation of the legislation so far?
No, I have not had. I've not met with the Chief Constable for a while. I've had no formal meetings with him. I have met with Bernie Higgins, though, who is the ACC who is in charge of Focus, which is the part of the police which is directly involved with this.
Have you ever requested a meeting with the Chief Constable?
Yes, it's by choice. I'm sorry, I don't understand what you mean by choice. I think we requested that meeting. But I mean, from time to time, meetings will take place. But I haven't. If what you're asking me is if I requested some kind of emergency meeting, no.
Right, thank you, John Finney, followed by Christian.
Thank you. I too welcome the report. I'm a member of the Equal Opportunities Committee, and we had Dr Morrow and a colleague along recently, and it was very enlightening. There's a phrase in there in the report, in fact, it's used in relation to the marches and parades, and it is the phrase balance of rights. Now, colleague Alison's quite right to say we've had a lot of correspondence in the past regarding this, and I'm of the view that there should be more dialogue between the authors and the people they have concern with, because I think that not only prevents conflict, but can resolve conflict. Can I ask in relation to the various groups there? So you mentioned Focus, you mentioned the Joint Action Group, and the Football-Related Disorder Group, if I noted that correctly. And there was a mention that
this is the official, yes, one of the officials level, yeah.
That there's Scottish Government officials on that group, clearly.
Well, Tom McMahon chairs that group.
Yes, indeed. But you also said Scottish Government officials. There are other officials, aren't there? There's mention being made of the very unpleasant events of the weekend with the young man, and I appreciate there's a live inquiry, and that is not only distressing for the individual who was subjected to a torrent of abuse, but also others who would have listened. How will the Football-Related Disorder Group pick up to that? Because it would seem to me that there might be an opportunity for early intervention if it was identified, for instance, that was hypothetically a grouping from a school, a college, a workplace, an opportunity for fairly swift intervention. Can it move that quickly, the group? Are there education officials, for instance, on it?
At the moment, it's a justice-led group because we're the main point of contact with the police. On that specific point, I would expect us to be picking up actions with education colleagues, for example. And I mean, it's a live inquiry. We're in touch with the police about how that's progressing, but I expect us to discuss next week the circumstances around those incidents, and again we would be looking for some view from football as to what responsibility it took for improving the behaviour of fans in certain grounds. And this was a lower league game. I don't think there was a big police presence there, but we expect fans actually not to behave in such a hateful manner.
And I mean, clearly it will be dependent on information coming from the clubs as to who exactly was there, therefore trying to establish how this came about. I should add that as well as this group, and I'm sorry, remiss not to have mentioned it before, there is also a joint ministerial group on sectarianism which does involve Education Minister, Local Government Minister, Sports Minister, and somebody, usually Hamza Youssef from the arts and culture side, because we recognise that the issue of sectarianism penetrates so many different areas that you have to have a mechanism by which everybody sits around the table from time to time to discuss the implications for their own particular portfolio remit.
Minister, would the ministerial group get information, for instance, from Mr McMahon's committee? I'm thinking back to the political leadership. An early and decisive response to something would be very helpful.
Obviously the officials from all of the portfolio teams will support that group, and you know, that would include information that comes out of this particular justice-led group. But I think I referred also to Education Scotland, you know, producing quite specific stuff in relation to sectarianism. So the education officials will be bringing that to the table as well. So that, you know, there is an opportunity for these things to be discussed. I mean, for obvious reasons, that joint ministerial group doesn't meet every fortnight or anything like that. But it is another level at which we are ensuring that the issues that arise in different aspects of society are being discussed by us as a government, and as members will clearly see, the advisory group were also very much looking at it from that perspective as well. We did have Duncan Morrow come to address one of our groups, I think, one of our meetings.
Of the ministerial.
Yes. Yeah. So, you know, that at a ministerial level, that's what's happening, as well as the officials. But the officials one is very much justice. But you know, there will be people on the education side, education officials who are involved in some of the things that have to do with the things that they're progressing. And for obvious reasons, the sports minister and her officials have an input, very particularly from the sports side of things.
Christian, followed by Margaret. Christian.
There you go, Minna.
Yes. We wait the little red light. The wrong one's on.
There you go, Minna. I would just like to ask the Minister about the timetable for the review for the Act. The Minister will be aware that a lot of groups are asking us to see if the timing of the Act could be put forward.
The timing of the review?
For the review.
Right,
could be put forward, and if an early review of the Act would be desirable. I know that the Act wanted 2 full seasons to be completed before we had a review, but that will stop in the 1st of August 2014, so you'll have a full year.
No. The research.
The research will be 1st of August 2014. Will give you a full year before the final report will be going back late in Parliament. Does the Minister maybe see that it will be a possibility for this to happen earlier?
Well, the 1st of August 2014 will complete the 2nd full year. And that is the ingathering of the evidence and the work that the Stirling University Research Department will be doing. You know, we've given them a timetable by which to work. If we were to go back and try to change that, you know, I'm not entirely certain what their response might be, because until August 2014, they haven't got all the information, and that's at that point they would start to be doing the analysis of it. Of the 2 full years, 2 full years' work. You know, we are now a good 2 years down the line from this Act being implemented, and we're coming close to the end of that 2-year review period that the Act provided for. And I just don't really see any great need for that to be changed. I couldn't now step in and ask them to do something differently to what they've actually been instructed and provided for. And that process, because it's being done independently, because it's being done through Stirling University, is going to give a proper, comprehensive, quality-assured, evidence-based evaluation, which will be, you know, I hesitate to say incontrovertible because nothing is ever incontrovertible, but will be as solid a piece of work as you could possibly expect, and as robust a piece of work as you could possibly expect, because it will have been done over 2 full years, so that you wouldn't, you're not short-circuiting anything. You're actually doing proper a proper piece of work. And I think also, don't forget that the researchers, the Stirling University people, have got to have the opportunity to spend time interacting with the football authorities, the clubs and all the rest of it, to make sure that they get a full response from them as to how they feel about the first 2 years. And different clubs may have very different attitudes towards this. I don't know.
If I can may ask as well, Corina, if the Minister sees there is any opportunity under Section 1 for the power to make modification in the Act before the end of the process?
Well, I mean, we will have to wait and see what the full review tells us. I mean, obviously, I can't really answer that at the moment. It's something that if the review came forward with suggestions, we would have to take those suggestions seriously, and we would take those suggestions seriously. And remember that review, that report, will go to Parliament. That's a report that will be presented to Parliament. So the whole of Parliament will see the same recommendations, and at that point, we can then have a discussion and conversation whether or not it is considered. But at this stage, I can't really answer that, I'm afraid.
So you don't forecast anything happening before the 1st of August 2015?
No, it would be nonsensical to do something while this review was ongoing. When we know the review is going to be published, they're the independent researchers. They're the ones that will be able to tell us whether or not they think something needs to be tweaked or not. And I don't know. I can't say what they will come up with. I really have no idea.
Thank you, Minister.
I'm just looking, Minister, at, I appreciate that the review finishes covers the period 1st of August 2014, and the Act says that it must be laid, the report of the review, by 1st of August 2015. Is there any opportunity, or do you foresee any opportunity either for that being earlier, or for there being an interim report?
Well, I mean, that August 2014 is the evidence gathering.
Correct,
end.
but then the
researchers then have to work on the evidence
that
they've taken in. I mean, at this stage, I can't answer whether or not there is an opportunity. What we've said, I mean, August 2015 is the last date.
Yes,
that's the deadline. Right. So, at this stage, I've no idea whether or not the researchers at Stirling University might come back and say, well, actually, we can do that in less time if you want to. I don't know.
So there may be an opportunity. That's as far as one might go.
I don't want to be drawn on that because I don't know the answer to that. I genuinely don't know the answer to that.
Thank you. Margaret?
First of all, I welcome the fact, Minister, that we seem to have moved on considerably since the committee last looked at this issue. And you'll be aware that, I have had deep reservations about the effectiveness, the need even, and certainly the drafting of this legislation. Is it the case then, I wonder if you could confirm that racially aggravated breach of the peace charges have dropped, and at the same time there's been a corresponding increase in the Section 1 Offensive Behaviour Act type charges, and this, may be understandable given that carries a more robust sentence?
Well, some of the, as always happens when new criminal legislation is enacted, there will be a shift away from using previous charges. And because this particular piece of legislation here was specifically designed to catch activity around football matches, and related areas, then I would have always expected that some of the Section 74 stuff would be instead reflected through this piece of legislation. So I don't find that a particularly unusual thing. We've certainly seen the Section 74 stats come down, and obviously we now have offensive behaviour football stats. But if you combine the two, in total there is still a decrease. So we're still making progress. You have to just add the two together. I mean, one of the issues about the Section 74 stats was always, the question of trying to establish the extent to which football and football-related disorder was part and parcel of this, wasn't always an easy and straightforward issue. It is now much more easy and straightforward to see that, because we now have this specific legislation which relates to the activity around football games.
Yeah. I wondered, therefore, is there any concern that, you know, if you look at the hate crime type offences and charges, when they come to court, they tend to have quite a high conviction rate, over 80%, but the Section 1 Act offensive behaviour type charges have had a conviction rate of only about over 60%. So again, we're going to the heart of the effectiveness of the
well,
legislation.
you're asking me now about conviction rates, which are something that it's not really my place to answer that. I think you probably need to address those questions to the Lord Advocate. I can make an observation, which is often that when legislation and the early cases are being brought, there's a period of shaking out required as legislation and things are tested. And you know, we're in a position where that might be happening, but I think you'd probably best be asking the Lord Advocate directly about that. There are other criminal cases where, as we know very well, conviction rates can be quite low. A lot of them are where they involve quite subjective evidence, and you know, they vary. Conviction rates vary quite widely across the board. My personal feeling is that what we're actually in the moment is dealing with a kind of shaking out as courts test, as prosecutors test, as defence counsel test new charges. And that you would expect to see that. The other thing is that I think that figure came out of just 1 year snapshot. And there's always a danger, as we've shown when I referred to the anti-Islam stuff, that in a 1 year you get a very, very specific kind of thing that makes something look different to what it might be when you're looking over a longer period. And therefore a 1 year snapshot, particularly when it's the very first year, effectively, I don't think is necessarily how it's going to be into the longer term. And this is also something that, remember, the review will be looking at the 2 years, so we'll begin to see kind of changes. But in terms of efficacy of prosecution, I think that you probably need to speak to the Lord Advocate about that.
I'm looking at
Thank you, Minister.
I'm just going to say, I'm looking at the letter from the Lord Advocate to myself in November last year, which he says, I consider the legislation continue to be used effectively by prosecutors in their role in deciding how to proceed in cases reported by the police. Correspondence attached to the letter refers to quotes failed prosecutions, close quotes. What is being referred to are charges under the Act which do not result in a conviction, and this can happen for a number of reasons, and then develops the argument about facts and circumstances of cases. But just to complete it, I think it is a matter for the Lord Advocate.
I think it's difficult for me to address that, because that really is about prosecutions and
sufficiency
and
of
conduct of cases. And I can just say to the committee that the analysis that was done last June will be repeated this June and each June thereafter. So you will get the second year analysis will be before you in June of this year, and you'll begin to be able to look at changes, or perhaps things will look the same. I mean, obviously I haven't seen it yet. I don't know what will be the outcome, but you will see that similar detailed analysis that you got last June as well.
Can I thank you? I think that's the questions exhausted. Thank you, Minister. And can I say to the committee, I think it would be useful to have a discussion about what we do with this next item 5 in the agenda, where we proceed. Quite content, which is our work programme. Thank you. Item 4, if you just excuse me, Minister, I'll just press on. Is consideration of one negative instrument, the Prison and Young Offenders Institution Scotland Amendment Rules 2014, SSI 2014/26. This disestablishes the visiting committees for HMP Aberdeen and HMP Peterhead, which have closed, as you're aware, of the new prison, and creates a visiting committee at the new prison at Grampian as from 3rd March. This instrument was not lodged in time to meet the 28-day rule. The Delegated Powers and Law Reform Committee reported to the Parliament the reason given for this breach, quotes, a failure in communication and planning within the SPS, close quotes, was, quotes, completely unsatisfactory, close quotes. The DPLR Committee has also drawn attention to the lack of saving or transitional provision to allow the visiting committees at Aberdeen and Peterhead to complete any ongoing complaints. In addition, it was written to this committee excuse me, and to the Scottish Government to advise that, similarly, no saving or transitional provision has been made in the supra-affirmative instrument on prison visiting committees that we considered a couple of months ago. We can have members' comments in relation to this instrument. No comments? Yes, thank you, Alison. Yep.
I'm interested in the point that the Sub-Ledge Committee have made about any transitional arrangements between ongoing work from HMP Aberdeen, the Visiting Committee at Aberdeen and Peterhead, and whether they'd be able to transfer over any other cases if they have.
Yeah. Well, if you're content, I think we could do is write to the Government and to the Association of Visiting Committees to raise those very points about transitional arrangements and ongoing cases in relation to the specific and also in relation to the broader question.
That would be helpful.
All right. Thank you very much. Right, we move into private session. Thank you. Clear the public area, please.